Hello. Today we're going to be talking about the First Amendment to the United States Constitution. First Amendment reads that Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for redress of grievances. Now, there's a couple of reasons why we actually have this amendment. During the Constitutional Convention, when they were actually writing the Constitution, there was a group of people that was not actually happy with how the Constitution was written, because these people who weren't happy about it thought that the Constitution granted way too much power to the central government, and this conflict of power arose between the Federalists and the Anti-Federalists. Federalists, who were led by James Madison, Alexander Hamilton, Ben Franklin, and George Washington, they supported the Constitution, and they wanted a strong federal government, or a national government. And the Anti-Federalists were led by Patrick Henry, George Mason, Thomas Jefferson, and they were advocates of a weaker central government with most of the power in the hands of the separate states. Because remember, they had just come out of England, and the reason they separated from England was because they thought that the king was a tyrant, and so they were worried that if they put too much power into the hands of the new government that they were actually creating, they might create a second tyrannical government, and they did not want that. So after the Constitution passed, even though they were dissenters, they were able to use Article 5 of the Constitution, which is the article that actually details how you propose and ratify amendments. So they actually used the Constitution that they hated to pass the first 10 amendments of the Constitution, which we call the Bill of Rights. And the Bill of Rights is something that safeguards the most precious American principles. Like, if you thought of what it is to be an American, I'm sure that a lot of the things that you thought of actually are guaranteed in the Bill of Rights, and actually mostly in the First Amendment, which there are certain First Amendment rights which are detailed in the actual text itself, and those rights are that there is no establishment of religion, there will be free exercise of religion, freedom of speech, freedom of the press, right to peacefully assemble, and the right to petition. And I like to think that there's the right to be adorable, even though I know that's not actually in the text, but I think that we let pandas. Now, the first of these rights is establishment of religion. Two clauses relating to religion in the First Amendment. The original phrasing was, Congress shall make no law respecting an establishment of religion. This has been one of the most controversial of our First Amendment rights, inspiring debate over what exactly constitutes a law respecting an establishment of religion. Because, like, back when the Bill of Rights was passed, Thomas Jefferson actually thought that there should be what he said, a wall of separation between church and state. But the basic principle that we rely on now has been that if the law shows government sponsorship of religion, the law is unconstitutional. And one example of this is Everson versus Board of Education. The problem in this 1947 case focused on was whether or not reimbursing the busing of children to private religious schools with state sponsorship of religion. The taxpayers in this instant were paying for both public and private school buses, so the court decided that the New Jersey law is permissible because their justification was that the taxes reimbursed the parents, not any actual specific church. So the court also said that Not reimbursing the parents of students who went to private religious schools would actually be discrimination based on religion. Justice Black at the time wrote the majority opinion, and in that he wrote his interpretation of the Establishment Clause. That is the interpretation that has influenced the court ever since, and therefore has become basically law. That the Establishment of Religion Clause in the First Amendment means at least this: neither a state nor the federal government can set up a church. Neither can pass laws which aid one religion, aid all religions, or prefer one religion over another. Neither can force influence on a person to go or to remain away from the church against his will, or to force him to profess a belief or disbelief in any religion. No person can be punished for entertaining or professing religious beliefs or disbeliefs, for church attendance or non-attendance. No tax in any amount, large or small, can be levied to support any religious activities or institutions, whatever they may be called, for whatever form they may adopt, or to teach or practice religion. Neither a state nor the federal government can, openly or secretly, participate in the affairs of any religious organizations or groups, and vice versa. In the words of Jefferson, the clause against the establishment of religion by law was intended to erect a wall of separation between church and state. And then that brings us to the second clause about religion in the First Amendment, which is the freedom of the exercise of religion. The original text was the part that said, or prohibiting the free exercise thereof. And basically, the exercise clause to us means that the government may not tell a person what to believe. The government does have the right to regulate certain religious activities. The Supreme Court, as a result of its decision in Lemon v. Kurtzman, came up with a relatively simple Lemon test to determine whether or not a law concerning religion is constitutional. A law concerning religion must serve a legitimate non-religious cause, and it must not be directed against particular religious sects, and it must not excessively entangle the government in religion, and so any law that doesn't actually meet those requirements will be deemed unconstitutional by the Supreme Court. Freedom of speech is our next freedom. It's, I think, something that many Americans take for granted, and it's also pretty self-explanatory that people are free to say whatever they want to say to some extent, though. The question really is, to what extent is speech protected, and then what is prohibited? And the general answer to this question is that when speech excessively intrudes on another person's right, it can actually be restricted. For a while, this was decided by the bad tendency test, which says that it came in 1907 and basically said that any speech that was made with the purpose of stirring up illicit or illegal activity could be legally restricted. This idea was kind of modified and focused a little bit by Oliver Wendell Holmes in 1919, and his idea was the idea of clear and present danger, and he thought that the definition and extent of freedom of speech to this, his idea is the definition and extent of freedom of speech to this day. His idea was that if speech were to create a clear and present danger that they will bring about the substantive evils that the U.S. Congress has a right to prevent, then Congress actually has the power to prevent it. So the only difference between these two is that the clear and present danger is a little less restricting, because it has to be done solely for the purpose of bringing about unlawful things. Whereas the bad tendency test, for example, could restrict a person from passing out pamphlets advocating strikes, whereas clear and present danger clause can only restrict the pamphlets if they like for example, advocated murder or some other really unlawful activity. Now, the next freedom is freedom of expression, and it's really, really closely tied to freedom of speech. In fact, in most ways, it's actually just an extension of the freedom of speech, because expression is the way that we as citizens like speak through our actions. This freedom is not explicitly stated in the First Amendment, but it is actually derived from our freedom of speech. And the most famous example of this freedom of expression is flag burning, which is protected by the case of Texas v. Johnson. And Johnson was a man who was actually protesting the certain Reagan policies, and in the process of his demonstration, he poured kerosene on the flag and set it on fire. And Texas then, at that point, had a law that outlawed the desecration of venerable object. That's a quote. So he was arrested on those grounds, and the question that was brought up in court was whether or not this state law violated Johnson's First Amendment rights, and the court, in a pretty split decision, decided that yes, it actually did, because flag burning did not violate any real state interests, so the law served no real purpose. And if you want to watch a fun, although I'll admit it's a bit corny, video about flag burning, you can just look up Penn and Teller patriotism on YouTube. It's fun to watch. The next freedom guaranteed by the First Amendment is freedom of the press, and this freedom is very similar to freedom of speech and expression, and it is actually stated in the amendment. But freedom of press guarantees the freedom of written things from any government intervention, but this freedom does not actually protect libel or slander. Libel is written defamation of character, and slander is oral defamation of character. But both words actually imply that the defamation is false, and to be illegal, the person making the defamation must actually have knowledge that it is false and must also do the defamation with malice. Another question that arises frequently with freedom of speech is the reporter privilege, which is the question of whether or not the reporter actually has a reporter has the right to keep their sources anonymous. And generally, the answer is yes, but there is actually no law preventing that there's no law that actually protects that privilege. So if a court asks a reporter to identify a source, the reporter lawfully has to, because the court can issue a subpoena, which will force the reporter to testify. Now, the last two rights granted in the First Amendment are the right to peacefully assemble and the right to petition. These two amendment rights are really rarely litigated, but that's not to say that that's not to say that they're not extremely important, because, I mean, when the colonies were still colonies, neither of these were guaranteed, and so the Boston Massacre, which was a major instigator of the revolution, it actually happened as a result of, we'll call it a peaceful assembly, and then also the colonies were never free to petition the British government. For example, their Declaration of Independence was, at heart, I would say, a petition for redress of grievances, which are guaranteed in the First Amendment. When the colonists signed the Declaration of Independence, it was very illegal, but they wanted to make sure that the people always had a voice, which is why they gave them the right to petition the government in the First Amendment. And that's pretty much the First Amendment in a nutshell. And it doesn't actually matter whether or not you agree with the First Amendment, because if you disagree with the amendment, You can just go ahead and talk about it. You can even petition the government to repeal it. You could publish your views in a newspaper. You could actually create a religion focusing on your opinion of the First Amendment. But just remember, while you're doing all those things, that the USA guarantees you the right to do them thanks to our First Amendment.